My name's Joseph Kreps. I'm a DUI defense attorney in the state of Alabama. I wanted to talk to you today a little bit about the field sobriety test entitled the one-leg stand. It's part of the 3-test battery, which is the standardized field sobriety test used pursuant to NHTSA guidelines in the manuals that they put out that the officers are trained under. The officer is supposed to give you instructions, and then they're supposed to demonstrate, and then they're supposed to score your test. It's important that you understand that there are standardized instructions that should be provided because you're being scored on that. And if the officer does not perform the administration of the test properly, then our argument is that because the arrest decision was made and these instructions and the administration of the test was not done pursuant to the standardized manner, then the arrest or the probable cause for the arrest was not valid, and therefore the arrest is not valid and the charge should be dismissed, or at least all of the evidence suppressed. The manual even states that if these are not done pursuant to the standardized manner, that the validity of the tests are compromised. And of course, we would argue that that means that probable cause should not be based on these tests if administered improperly. The instructions on the one-leg stand are quite simple. The first one is the officer will tell you to stand with your feet together and your arms down by your side. Now, the officer should also demonstrate this for you just so that you have a good idea as to what you're supposed to be doing. The officer will then tell you to maintain that position until he tells you or she tells you otherwise. In other words, you're supposed to stand there and not begin the test until the officer tells you to begin. The officer will then tell you, when I tell you to, I want you to raise one leg, and it can be either leg, you get to choose, approximately 6 inches off the ground, okay? And they want you to have your foot with your toe pointed out, both legs should be straight, and you're supposed to look at your elevated foot and count out loud in the following manner: 1001, 1002, 1003, until told to stop. Now, the officer is supposed to ask you beforehand if you have any medical issues or any conditions that would cause you not to be able to perform the test. If you've had knee surgery, if you've had back surgery, and really if there's some issue with your physical ability to do the test, then the officer has to make the decision whether or not to do the test. In most circumstances, the person would say, I had back surgery a month ago, I can't do this. The officer would then move forward with the test and have them perform the test anyway. The officer will then ask you if you understand the instructions and then tell you to begin the test. What the officer will not tell you is that you are generally going to be standing there with your foot in the air for 30 seconds, and you'll count to 30 seconds, and then the officer will abort the test because that the time period for the test is 30 seconds. Now, the officer is looking for these cues or clues. Did you sway while balancing? Did you use your arms to balance or raise your arms more than 6 inches? Did you hop during the test? Did you put your foot down before the 30 seconds had passed? And the last one that the officer's looking for is if you cannot do the test. Now, that's not necessarily a clue, but if you absolutely can't do the test, the officer would abort the test and or abort the instructions and not start the test. But if you put your foot down 3 times, then that is a clue, and the officer would then score that as being your inability to perform the test. Again, my name's Joseph Kreps. I'm a DUI defense attorney in the state of Alabama. If you have been charged with driving under the influence anywhere in the state of Alabama, we want to talk to you. We've handled thousands and thousands of DUI and related traffic cases throughout the state of Alabama. If you have a DUI, we want to talk to you. It doesn't cost you anything to talk to us. We'll go through an analysis of your case with you, talk to you about your case, and let you know what we can do to help you. All you have to do to begin the conversation with us is visit our website or call us. The phone number to call us is 866-348-2889, or you can visit our website at alabamadui-attorney.com. That's the symbol dash attorney.com. Thank you very much.